All right, we are good. I'm going to go ahead and hand it over to Tiera for this week's Seal the Deal.
All right, cool. So today we are going to talk about a super fun topic, which is quiet title action. So has anyone had any experience with a quiet title action yet, or know kind of what it is? Yeah.
Me.
Oh, how did that work out for you?
It was actually the first properties that John and I bought.
Oh,
Yeah, the guy bought them at tax sale, and there was something unrecorded, and couldn't. The guy actually, the previous owner had passed away, so they had to track down. I think a relative, and I'm pretty sure that the seller that we were buying them off of just like offered him $500 to sign something off to him, and
yeah.
so we bought those.
Oh, perfect. Perfect. So that sounds like he got off the hook a little easy, which is nice because a quiet title action, when you have to go through the actual action in the courts, takes a lot of time and a lot of money, and it just halts everything. So everything you were saying is exactly what could lead to needing a quiet title action. The main thing that we see it with is a break in the chain of title. So we know that as properties are transferred from one person or people to another, every owner has to be accounted for in the next transaction to release their ownership. And now these new buyers, if they go to sell, everyone then has to release their ownership onto the next one. And having a break in the chain of title means, say April and I bought a property, but when it was sold, I signed the deed. So now there's a break in the chain because where'd April go? Now, in a perfect world, she's just right down the street. She can come sign, everything's fine. But what leads us to having to do a quiet title action, for example, among a million other things, would be she is not, here with us any longer, or she doesn't want to talk. We can't find her. We can't get a hold of her. There's just no way for us to get her to relinquish her portion of the ownership in the property. And so we would start a quiet title action. So the definition is just a legal proceeding. So this does go through the courts. It's not something that your title company like kind of just does for you, although I can recommend, I have people that do it. It does go through the actual courts, and it's used to establish or quiet ownership of a piece of real estate if there's a dispute or a cloud, if there's something like that. And we'll go over a few ways that you might end up having to do a quiet title action. Again, they're endless. There are so many different situations that could arise that I couldn't even begin to tell you, all of them. But basically, it's resolving a conflict, and it's having the current owner say, whatever has happened before, it's just mine now. Like, we just need to get rid of that. We can't have it come back and bite us in the butt. We can't find this person, or this just isn't something that's relevant anymore. And I want the court to say, it's just mine, and we can move on with this sale. So some common scenarios that we end up with a quiet title action is missing or conflicting heirs. So I know I've told this story to some of you before, and luckily we didn't have to go the quiet title action route, but this was prime for it. So we had a property that was inherited. And it was inherited to 7 siblings, and then they sold the property. So that purchase was already complete. And then we are on to the next transfer of this property. And what we notice, though, is that on the last deed, only 6 of the 7 heirs have signed. That is a break in the chain of title. So we couldn't continue until we figured out what was what. Now, again, in an ideal world, we just find, Brother Joe over there, and he just signs it. But Brother Joe had passed away. He's gone. So now we have to find his heirs. And I want to say he had 3 or 4 children. So we had to locate all of them. And again, it worked out that we were able to locate all of them and have them sign. But in most cases, they're going to be like, who are you? I don't know what this is. They're never going to answer the phone. They're not going to answer any mail. We're just stuck. And so in that case, we would have the sellers that we do have start a quiet title action that says, we're here. This is our property, this other guy, Joe's kids, they don't want anything to do with it. They're not willing to sign anything. They don't know anything about it. And then the court would go through its proceeding to have the record show that that stuff doesn't matter anymore. And you can just kind of proceed without that. The next thing is a property was inherited. It's kind of the story I went into, but not all heirs are accounted for. Forged or faulty deeds. So if we find something along the chain that was a deed that is faulty for whatever reason, we can kind of go through the quiet title action process to almost just do away with that. Like it didn't have, here's the owner now, and we're just going to move on that way. And you can kind of read through the rest. Break in chain of title. A deed 3 owners ago wasn't recorded properly. Unreleased mortgages, liens, things like that. So the real thing, the real information here that's going to help you is understanding what the process is. And it's not because you're going to have to go to court to do this, but when it comes to, okay, this is our last option, and it is a last option. This is not something I would ever suggest right up front. Your seller then needs to understand what the actual process is if we're going to go through this. So the very first thing to understand is if we get to a point where I or whoever you're using for title says, you know what, we are 100% out of options, we're going to have to do a quiet title action, you're not closing anytime soon. Not going to happen, unfortunately. And that's why it's the absolute last resort. So it does, again, go through the actual court. So the plaintiff is going to file a civil action and name any parties with potential interest. So again, in the example I gave you, it would be Brother Joe saying, you know what, he's gone, his kids don't care, like we need to kind of erase his ownership in the property. The plaintiff would be the current owner of the property. The service process. So the court has to attempt to notify all of the parties, known or unknown. They have to do everything they possibly can. And then that is going to start a response period. Now, luckily, this only takes about 20 days. I know 20 days is a long time when you're trying to get something closed, but they only have 20 days to respond or contest what's going on. So maybe that letter that gets out finally does, pique the interest of one of Brother Joe's kids. And then, he shows up and says that, he will or won't sign the deed to relinquish his ownership. And then we kind of go down whatever path that leads us down. If it is uncontested, then the judgment is issued. But if it is, then you might have to go to court to kind of have the judge decide which way it's going to go. Either way, the court order is issued saying one way or the other that the title is clear, or Joe's kid now is causing waves in the pool of the closing. And then the judgment is recorded, and now we can see how that has transpired, so that for our transaction and for any future transaction, we can see that quiet title was placed there. And so anything that might be a red flag for us as we're looking through the title, hopefully then we can match it to that quiet title action and say, okay, this is taken care of. It's not any of our business anymore. We can move on as normal. The most important information, though, is it can take usually 4 to 9 months from filing to it being recorded and complete, and it is not cheap. So you're going to have an attorney do it. Again, I do have plenty of attorneys that I work with that I could get you into contact with if you would ever need to do this. But costs range from like $2,500 to upwards of 10 grand, depending on where you're at. I've never seen it be 10 grand, but I've definitely seen between like 2,500 and 5,000. Questions on that so far, on the process, or what might get you in the situation where you're going to have to do a quiet title action? Cool. So you guys are pros, absolute pros. I love it. So I did skip this one over just because I wanted to get to the process, but there are some situations where quiet title action is not appropriate. It kind of can seem like a quick fix to just kind of get rid of whatever's plaguing title, but that's not the case. There are specific guidelines for what you would want to do a quiet title for. So you can't have just kind of a Joe Schmo that hears about a quiet title somewhere. I don't even know who would be talking about it, like in a bar or something, but they hear about it and they're like, you know what, if that's going to quiet any interest for the life of the property, then I want to do it. Like you can't do that. No one's going to do that. No lawyer is going to take you on for that. Any active disputes over ownership or fraud accusations, that has nothing to do with a quiet title action. And then you also cannot use it to clear valid judgments or liens or any other clouds on title. So you can't use it to just clear an unpaid mortgage or an unpaid lien. It doesn't work that way. It won't just disappear. If it's active and legitimate, then you just have to pay it off as you normally would. So you can't just try to use it to erase things that are actually legitimate. So that's honestly the whole thing. I mean, that's the quiet title action situation. So in my normal process here, we're going to do a little question and answer just to make sure you guys have a good understanding. So I'll just show a little situation and you tell me yes or no. I would or wouldn't do a quiet title action. There's only like 5 of them, I think. So number 1, an owner bought a property at a sheriff's sale and the title shows a 1990s mortgage still open. Do you think this is something that you would or wouldn't need to do a quiet title action on?
I say would.
I got a yes. All right, I agree. So the lien is unresolved and you might have to do that quiet title action to remove it. The big thing here is because I know I just said, well, if it's an active mortgage, you have to pay it off. It's from the 1990s. So we need to look into that. We need to figure out why that is. Is that bank even still operating? What has happened here? So that's not just a regular active mortgage from 5 years ago. That is an open mortgage from way back when TV shows are still good. The next one is the seller inherited a home, but one sibling can't be located. Do we do a quiet title action or no?
Anybody want to guess? I say yes.
My thumbs up was a yes.
I figured. All right. So yes, absolutely. Any unresolved heir issues create any ownership ambiguity. And I tell you guys all the time, I am absolutely not in the business of ambiguity. It has to be black and white for risk assessment, purposes. So yes, we have to know exactly what's going on there. The next one is that the deed was properly recorded and the title is clean. And the rule is that Christina can't answer, but somebody else has to.
Okay, I'll be quiet. I can't help it. I know the answer.
No.
Exactly. No. It's all good. Everything's fine. There's nothing to worry about here. So we would just move on. And then I think this is my last one. The seller says they got the house from a friend, but no deed exists. Do we or don't we have to do a quiet title action?
Well, my answer is no.
Oh, yes. So you can get the house from a friend or inherit the property and all of those things, but you still have to record a deed. So since that wasn't recorded, then no legal transfer occurred. Now, this could kind of go either way. I see where you're going with this, because if friend is just down the street, then we can get a deed recorded and, call it a day. But if we can't get a hold of friend, or friend's not willing to do the legal transfer, he just left it to you, or friend is dead, all these different avenues you could go down. If we can't take the normal route, then we're going to have to quiet any ownership possibilities to any heirs or anybody that the friend might have had any ties to that might try to claim any ownership to the property. And then I lied. Maybe this is my last one. The property has an IRS lien for unpaid taxes. Just a regular schmegular IRS lien that we come across all the time.
I know this one.
No.
Well, you can answer it because, there we go. April spoke up. All right. Exactly. That's just regular. We come across that all the time. We can't erase a valid lien. Plus, you don't want to wait 6 months and spend $3,000 to do that anyway. Like, why would you want to do that? But you would be surprised. There's a reason these are on here. So that's just kind of the long and short of a quiet title action. They suck. You're not going to close anytime soon. It's an actual court proceeding, and it's expensive. And I was talking to Becky. I don't know if you guys know Becky Offit that we work with, and she's like, "Yeah, it's basically just telling anyone squawking to shut up," which is true, because it also is going to cover any disputes over, whose property is whose. Like, so dad dies and it doesn't say specifically what to do with the property, and brother wants to sell and sister doesn't. Those kinds of things. So it can do a lot of things as far as clearing title to move forward in a way that isn't so ambiguous, but it can't just clear things that you don't want to deal with. So that's the whole story. Questions, conversations, questions unrelated to quiet title actions. What do you got for me?
I've been through my fair share of quiet title actions, both myself and for clients.
Yeah. What's the quickest one you've ever gone through?
I mean, I don't know if there's a quickest one. I mean, a lot of times, you know what I mean? The attorney just always tries to reach out to wherever the cloud exists, and we offer them a couple $100 to sign.
Yeah, that's ideal.
Yeah. Deal. You know what I mean? Like,
yeah,
meet with us for 15 minutes and we'll pay you for your time. You know?
Yeah, that's ideal. At least when you can actually track someone down, then you can not have to go through that whole process and just, like you're saying, pay someone off and get it done.
Yeah. I mean, that seems to be the easiest way, but I mean, I've had some linger on for 6 to 9 months.
Yeah.
You know what I mean? So, because sometimes when they do the law journal posting and then they post in the newspaper, sometimes people do come forward, even if they don't have a valid claim for it.
Right.
And that's the thing, is now you have to investigate, do they actually have a valid claim?
Yeah.
So you do get people, it's like, oh, that was my grandma's house 57 years ago. You know what I mean? So, I mean, it's unusual, but it does happen.
Yeah, they can definitely get messy. That's something that no one wants to hear, that's for sure. And it's not something that you'll have to figure out on your own, just to be clear, whether or not you have to do that. That's something that is squarely in my wheelhouse. So someone from my team would say, hey, unless we can do this, we're going to have to take the quiet title action route, and refer you out to some attorneys that could help you if you don't have one. So this is just more so that you have an understanding of what we're talking about when we say that, if, unfortunately you do end up in that situation, and what kind of happens from there.
Yeah. Tax sale deeds are notorious for needing quiet action, because a lot of people, a lot of people who are not formally educated on the process of purchasing properties at the tax sale, they used to call these sales free and clear sales, and they stopped doing that because they're not free nor are they clear.
Not at all.
So when you pull the record on these houses, even though you can walk into the courthouse and you've spent $5,000 or $6,000, whatever it is, sometimes they go for $500. You know what I mean? You're buying these properties. When you pull the title, well, it's got a mortgage on there, and it's got a sewer lien on there, and it's got adult probationary liens on there. And, so I think it's important for people to know that just because there's, they went through the process, doesn't necessarily mean that those debtors can't come back against the property, because the counties are notorious for not properly notifying or posting.
Exactly.
Because they don't care. And, even if they can't come back, even if they did their due diligence, it's still on the record.
Yeah.
And, another thing is, like you were saying, with like IRS, probation, child support, those types of things, like, good luck getting those removed. Like, the government wants their money, and they don't care who they get it from. They're not removing it.
Yeah, absolutely. So hopefully you guys don't end up in that situation, but if you're in the business long enough, it's going to happen. So just so you know what to expect. 2 more things I have for you guys. One is there anything in particular that you want the next session to be about? I have trusts, what can be liened, what to collect at a listing appointment, calculating taxes like manually, or the reality of the rush order. Any of those sound appealing?
All of them sound appealing to me. One thing I'd really love to see if you could weigh in on a conversation that I keep having over and over and over and over again with so many agents is the importance of validating or I guess confirming identity.
Oh gosh.
And
yeah.
how, identity fraud and fraudulent deed transfers and stuff, because that's becoming way more prevalent in the market.
Yes.
I know that, even since opening in the 2 years we've been here, we've had one. Tiera, I think you were involved with it. Were you involved with that one?
I know, it's not ringing a bell. I don't know.
Maybe it was a different closing company, but we had a fraudulent seller who posed as somebody who they were not.
Yeah.
So any guidance or information you could provide on that you're seeing on your end, because we're getting a lot of scammers into the market right now, and some tips and tricks on how to avoid that. I ask everybody to make sure you're getting ID from every seller,
Yes.
every buyer, like you are required to get photo ID. I don't know that people are or understand.
Yeah. And honestly, that's good for a few things, because if you haven't seen their ID, you can get, I know I do, I get through the whole process and without seeing someone's ID. And then you get to the closing table and so many different things could go wrong. So to answer your question first, the most accessible thing I would suggest you do if you're working with a seller is to, as you're saying, get their ID. And then if you pull up on the assessment page to confirm that they are the owner, then you can then compare the ID to the assessment page and make sure that's exactly who it's supposed to be. With a buyer, I don't know if this is normal, but I maybe would just look them up on social media just to make sure they exist, that the picture matches the name. You don't have to go back to 2007 when they first opened up their Facebook page, but just to make sure there's some sort of link between who they are and who they say they are. But the other reason is to make sure the name is correct. That happens so many times where somebody will misspell their name, like on their loan application, or their name is Joseph, but then they start putting Joey on everything. And especially if there's a lender involved, that can't happen. So if it says they put their application in as Joey, or they have you write their AOS as Joey, but their name is actually Joseph, then that causes a problem at closing, and all the docs have to be regenerated. So there's a lot of reasons to make sure you have that ID up front as soon as you can get it, and to do just the tiniest little bit of research to make sure that's exactly who it is supposed to be.
Yeah.
What else you guys got for me? Who's going to the happy hour on Thursday?
I am, obviously.
I should
Me
be able to
too.
make it.
You said you won't, or you should?
I should.
Oh, good. It wouldn't be a party if you didn't.
I wouldn't want to let everybody else down.
All
Who's
right.
taking bets on what Mark's first drink order is going to be?
Oh, come
Oh, wait.
on now. It can't be
What
that
are the
easy.
options?
Option number 1, old fashioned. Option number 2, old fashioned.
Right, yeah.
Number 3, old fashioned.
Okay. I guess I've never paid attention to what you drink, Mark. I'm always drinking with you, so I don't know.
Well, yeah, I should be there. It'll be great.
All
Should be a lot
right.
of fun.
Yeah, sounds good. Well, I will be there too. I look forward to seeing you guys. If you need anything in the meantime, you know how to get a hold of me. Call me, text me, email me, carrier pigeon, whatever you need. Jamie knows how to get a hold of me. Oh, she left. I'm picking on her. She's been calling me or texting me at least 3 times a day for the last 3 weeks.
Well, good.
I love it. I
you guys are
absolutely love
busy.
it. What's that?
Instead, it means you guys are busy.
Exactly. Yeah. It doesn't bother me at all. She's like, I'm so sorry. I'm like, no, keep going. More questions means more business. Let's go.
Well, thank you so much for today's training. We appreciate you as always. And we'll see you again, same time, same place in 2 weeks.
That's it. All right.
All
I'll see
right.
you guys. Have a good one.
Thanks.
Bye-bye.